Thank you, everyone, for joining us for today's webinar, The Supreme Court and Trans Sports. We turn to our moderator for today's discussion, our Arnold D. Casoy Scholar of Law and the Federal Policy Director here at the Williams Institute, Alana Redfield. Alana?
Thank you. Thank you so much for joining us. This has been a very intense week reviewing the oral arguments and all the legal claims and discussions in these cases before the Supreme Court. We have two cases this week. One was West Virginia versus B.P.J., and the other was Little v. Hecox. These cases deal with the experiences of trans athletes attempting to participate in sports that are consistent with their gender identity in those states that have enacted bans. I am joined by an amazing, exciting panel today to talk about the oral arguments, talk about what's going on in the cases, and to talk about the larger legal theories at play here. So without any further ado, I will introduce them. I should note to begin that I am your moderator for today. My name is Alana Redfield. I use she, her pronouns, and I'm the Federal Policy Director and Arnold D. Casoy Scholar of Law at the Williams Institute. I am joined for today's panel by Professor Katie Iyer, the Judge Guido Calabrese Scholar at Rutgers Law. Katie is an anti-discrimination law teacher, scholar, and litigator. Her scholarship has been the recipient of numerous awards, including the Duke of Minier Award, and has also been credited with influencing the Supreme Court in the case of Bostock v. Clayton County. We are joined as well today by Andrew Flores, who is an associate professor of government at the School of Public Affairs and a visiting scholar at the Williams Institute at UCLA School of Law. Andrew's research focuses on attitude formation, attitude change, and public policies affecting LGBTQ populations. Andrew was also our amicus in our submission in these cases before the court. We are joined as well by two attorneys from Boies Schiller Flexner. Boies Schiller Flexner represented us in our submission, and we're very grateful for their support and help in preparing and submitting our brief to the court. First, I'd like to welcome Michael Huerta, who is an associate at BSF. Michael's experience spans a variety of issues, including antitrust, appellate, securities, administrative law, and complex commercial litigation. He's also very proud of his pro bono practice, which includes numerous immigration cases, and he has a passion for voting rights and election protection cases. Joining Michael, we also have Joshua Quay, an associate at Boies Schiller Flexner. Joshua practices complex commercial and intellectual property litigation, and is also active in the pro bono legal community and supports several LGBTQ and veterans causes. So welcome to our panel today. I'm very excited to get started in jumping right into the topic. So to do that, I'm actually going to ask Joshua to kick us off and tell us a little bit about the cases.
Good afternoon, everyone. As Alana mentioned, thank you so much for joining our webinar this afternoon. My name is Joshua Quay, and I'm just going to start by grounding us in some of the basics of the case, who's in these cases, what each side is asking the Supreme Court to do. At a high level, the court is considering two cases. Our case is West Virginia versus B.P.J., and the cases concern state restrictions on transgender student participation in school sports and what federal law, especially Title IX and the Equal Protection Clause, permit or restrict. January 13, the court heard oral argument in West Virginia versus B.P.J., and in that case, the petitioner, West Virginia, is defending a state rule that limits participation on girls' teams based on sex as the state defines it. The respondent, B.P.J., is a transgender girl who challenges that restriction as unlawful when applied to her. The posture of these cases is fairly straightforward. The state asks the court to uphold its state-based eligibility rule for girls' athletics. B.P.J., on the other hand, asks the court to hold that excluding her from girls' teams violates federal law. A key feature of the case, one you'll hear discussed today and one that was echoed throughout this case and its companion case is that these challenges are framed through two major legal lenses. First, Title IX, which generally prohibits discrimination on the basis of sex in federally funded education programs, while longstanding federal regulations also recognize sex-separated athletics in certain circumstances. So there the dispute becomes, what does sex mean in Title IX within this particular context? And how do the athletics restrictions here and also Congress's authorizations of them shape what schools and states are able to do? Second, regarding the Equal Protection Clause, as a constitutional issue, the core question there is whether a categorical exclusion is permissible based on a sex-based classification, and whether heightened scrutiny applies, whether the policy is sufficiently justified and sufficiently tailored. There are several justices that asked very interesting questions there, testing the fairness and safety rationales of that rule as it was applied in this particular case and as it concerns intermediate scrutiny.
Thank you so much. I'm excited now to sort of dig into some of these issues a little more as they were discussed. We had a discussion in the Hecox case that focused more on equal protection side, and then the B.P.J. case focused more on the Title IX side. So I'm going to ask Michael to start us off with the Title IX arguments. What was at play? What was going on in this case?
Uh, Thank you for having us, everyone. Josh gave a really good overview of Title IX, and to dive into it a little deeper, remember that essentially Title IX is a funding statute that prohibits any school that takes federal funds from discriminating on the basis of sex. And on the surface, that would include athletics, except, as we heard yesterday, sports is not an ordinary Title IX setting. And that's because of an amendment that we heard passed around in both arguments, and that's called the Javits Amendment. The Javits Amendment is a 1974 amendment to Title IX, originally only applied to intercollegiate sports, but subsequent regulations have extended it beyond that. And it's that amendment that required agencies to develop regulations and is largely understood as permitting sex-separated teams, despite the text of Title IX prohibiting discrimination on the basis of sex. And that's important to understand because yesterday, or a couple of days ago, rather, all of the justices worked on this presumption that sex-based classifications in sports are permitted under Title IX. And so, what does all of that mean for our case? Well, remember that here, West Virginia defined sex as the biological sex determined at birth. And B.P.J. respondent in our case wasn't challenging that definition. Instead, respondent argued that within that definition, Title IX still prohibits any application of the definition or the rule that would treat her differently from other girls or prohibit her from participating in other girls' sports. The entire idea of that argument for BPJ was that the whole purpose of the Javits framework is to promote fairness and opportunity and safety. And within Title IX, at least that's applied to her, separating out and preventing her from participating in sports doesn't achieve that purpose. West Virginia's theory was a lot more straightforward. They said that the definition in their statute, in the regulation, and understood by Congress at the time Title IX was passed, permits these kind of sex classifications, and so the court should uphold their statute. And so that's really the Title IX framework. And as we'll see throughout this conversation, there are real big implications on how Title IX defines sex, and really even if Title IX needs to define sex in this case.
Thank you so much. That's a perfect foundation to start with. And now I'm going to ask Professor Iyer to talk a little bit about the equal protection issues here and the framework there.
Thank you, Alana. So in terms of the equal protection claims in these cases, there were a variety of arguments made in the briefs, but I would say at oral argument, the focus really narrowed down to a couple of primary questions. So first, mostly the parties and the justices seem to agree that there is a sex classification here, right? The law does in fact operate on the basis of sex. And under the Supreme Court's well-established precedent, sex classifications get what is referred to as intermediate scrutiny. So this type of closer look review in which the classification has to be supported by important government interests and be substantially related to those interests. What's unusual about these cases is that the plaintiffs here have conceded that using a sex-based line is okay for most people in these circumstances. So they've agreed that the state generally has good reasons related to sex-based competitive advantage to divide those assigned male from those assigned female at birth in sports. So a lot of the discussion at oral argument really focused on what is referred to as applied claims. So the basic idea here is, does it matter if, as the plaintiffs claim, there is this meaningful subgroup that the government's good reasons don't apply to? So for transgender people who don't have any sex-based advantage, either because they're too young to, or because they've medically mitigated it, are they allowed to bring a challenge about them specifically and force the state to show, oh, there's a good reason here? Or is the fact that the rule is overall a decent fit for what the government has done good enough? So that was really the primary focus of the arguments on the sex discrimination equal protection claim. We're going to come back to that in a moment, when we talk about the specific briefing in the case. The other argument that's important to stress here was an independent argument that these laws independently target transgender people, and that transgender people themselves are the type of group who, when they're targeted in the law, should get a closer look from the courts. So this is something that the court hasn't ruled on to date, but it could hold that transgender people are the type of quote unquote discrete and insular minority where we have reasons to worry when they're targeted in the political process. I'll come back to that argument in just a moment, but I'll note, just previewing a little bit our discussion of oral argument here, that it seems possible that the court might try to sidestep that issue here by saying that these laws don't target transgender people at all. I think for most people, this seems bananas, like an upside down world. We all know these laws were about transgender people. The people enacting them did not try to hide it. But of course, the same was true in Skermeti, and it did not stop the court there from saying that trans people were not targeted, and thus they didn't need to reach this same issue. Assuming the court does not sidestep the whole issue in this way, there are a set of criteria they would need to address in order to evaluate whether laws targeting transgender people should get this type of closer look review. So those criteria are, has the group, here transgender people, been subjected to a history of discrimination? And one of the good things about this issue not being resolved in Skermeti was that that issue was sort of flagged and briefed more fully in this case to substantiate there really is such a history. Does the characteristic bear no relationship to the ability to contribute in society, such that we should be suspicious of its use? Is the characteristic immutable or distinguishing, such that it serves to define the class? And then finally, does the group lack political power sufficient to defend themselves in the political process? There are a lot of good arguments that transgender people satisfy each of these criteria. Some of the lower courts have held this, in fact. But at this point, we're going to turn things over to Andrew to really focus in on one of these specifically, since his brief addressed the political powerlessness question.
And let me tee it up a little by saying, first of all, thank you. That was excellent overview. And to tee up Andrew a little bit, I'll say at the Williams Institute, we're by and large focused on research and science and really understanding the lived experiences and the realities of LGBTQ lives in the context of policy. And so political power, interestingly, is something that Andrew has studied. And I'll let you get into that. But I don't want to gloss over the fact that another big piece that the Williams Institute does is estimating the size of LGBTQ populations using the best quality data available. And in fact, Justice Sotomayor did actually refer to the estimates that Andrew and another scholar from Williams, Jody Herman, put together this year. So that was very exciting. So anyway, with that like exciting tee up, I want to pass it over to you, Andrew.
Yes, thank you, Alana and Katie, for the background. And so our brief that our amicus that we submitted to the court was really trying to hone in on one component of the major factors that affect whether or not the court should consider a group to be, or a classification to be suspect. And so we thought that we had the expertise and data to kind of inform a discussion around the political power of transgender people, whether or not as a specific classification or a subgroup, as the court in oral argument really kind of honed in on. They were far more interested in thinking of this as a sex classification, and that trans people may be a subgroup within that kind of classification. And so the challenge for us in that regard was that the court has never actually really defined what it means to have political power or to lack political power. And that means that there's actually like a moving target. Sometimes the court's reasoning is that having a small size of the population is in and of itself a lack of political power. However, the court has also kind of looked at other features in electoral and political politics in order to kind of come to conclusions where is a group underrepresented in legislative branches and other places of official decision making that keeps that group from being able to kind of have a say in political outcomes, as well as do certain groups or do certain issues face systemic bias by public opinion? Like, what does the public think versus what do the individuals of that group think? And is there a systematic bias that excludes that group? And so our aims in this brief were not to say that we're going to place our understanding of political power in any one bucket of how the court has kind of thought about or reasoned about political power, but said out, regardless of whichever yardstick that you're using to measure who is powerful and who is powerless, that the empirical data do show us that transgender people tend to be disempowered if you're looking at legislatures and, say, executive branches or the governor's office to affirm the rights of trans people. And in that regard, this is one indicator of where the court should find itself motivated to say, this group needs another type of resource, another type of outlet that can actually affirm those rights, because the majoritarian political process has actually systematically failed them. And we make this case across many issues or many topics. I think some of the more important ones are also that my colleague Jody Herman and co-author and others have identified that transgender people actually have substantial barriers to exercising their voting rights because of voter identification laws and other laws regulating identity. And so even just being able to gain access to the franchise is burdened for transgender people. And so our effort in this discussion was to elaborate on the many ways in which law and politics, but specifically the idea that you can vindicate yourself through political processes and voting can actually give relief to transgender people, and that we didn't come to that conclusion, that we thought that there were systematic issues with that. And as Alana mentioned, we also talked about the relative size of transgender populations. And I just want to add there that an interesting discussion came up throughout the oral argument about, is this not burdening enough of people in order to trigger a heightened level of, say, scrutiny or a more searching inquiry from the court. And I thought that that, as in question as the as applied discussion, was confusing, or at least interesting to me, because if it works for 99% of the people, does the 1% not count? And when you're thinking about as applied challenges, is is that sufficient? And I'm not the lawyer in the room, so I'm hoping that some of my co-panelists have ideas about this. But it did kind of make me question, like, what does it mean to be politically powerless and then lack power because your size relative to the population is small, but yet you're still being identified and treated differently based upon a certain characteristic or category. And so I'll leave that there for our discussion for now.
Thank you very much. And so one of the things that brought us together as a group today was thinking about what we had submitted to the court. So both the Williams Institute, represented by our two Boy Schiller attorneys, and Andrew submitted this brief. And we also have a brief submission from Professor Iyer. And so I want to invite you to talk about it because I was thrilled and shocked and excited and all the feelings about how directly your submission related to what seemed to be one of the core inquiries for the court.
Yeah, I the brief actually got a mention at oral argument, which was like, for those of us who submitted amicus briefs and don't know if they're going into the ether, that was like, a very exciting moment for me. So the amicus brief, which I authored in this case, it's on behalf of a group of equal protection scholars, and it builds on some of my prior scholarly work. And it goes back to that first issue that we were talking about under the Equal Protection Clause, which is when and where, as applied, equal protection claims are available. So the states in these cases have argued essentially that it's good enough for intermediate scrutiny if 95% of those assigned male at birth, say, would have a competitive advantage problem, then the rule is a good enough fit. And it just doesn't matter if there's some other subgroup that the state's reasons don't apply to. So their argument is that's the difference between strict scrutiny, which applies to race, and intermediate scrutiny, which applies to sex. You just don't need as good of a fit for sex discrimination. And of course, for transgender people, this would mean that no court ever really has to consider whether a sex-based line is fair as applied to them, because transgender people are, as Andrew was just talking about, a sufficiently small slice of the population that if we're saying if it works for 95% of people, then it's good, the 95% cisgender people are always going to be there. So the amicus brief, which I submitted, takes up this issue and argues that the states are just wrong with respect to what the case law says on this issue, right? In theory, the case law could say either thing, but there actually is case law on this issue. There isn't a lot, as Justice Kagan acknowledged at oral argument, but there is some, and the case law that exists actually maps pretty closely onto the type of claims the plaintiffs are trying to make here. So where have we seen these types of as-applied claims in the equal protection context? The most significant context is in the context of cases involving non-marital fathers and non-marital children. So despite the sex discrimination revolution of the 1970s, the Supreme Court was not prepared to categorically strike down laws that treat unmarried fathers differently from unmarried mothers. So, for example, laws that gave all unmarried mothers the right to object to their child's adoption, but not all unmarried fathers. Those have generally been held constitutional. They still exist in various forms in this country. And that's because the court thought at the time these cases were brought, and perhaps today, we don't know, there hasn't been a case super recently, that there were good real world reasons for these laws. So a lot of people have disputed whether this is a stereotype or truth. But the court's reasoning in the 1970s was essentially mothers are necessarily there, they're present at birth. The court has carried this reasoning even into some of the more recent cases. While an unmarried father may not even know that they're a father, right? They may not even know of the child's existence. Um, but what the court also says in these non-marital fathers cases is even if that's true for most non-marital dads, and it's clear in the 1970s, they're kind of assuming it will be, right? That most unmarried dads aren't involved with their kids. So let's say the 95% figure that we're talking about today, that nonetheless, states can't just have a blanket sex-based rule. So they can't say no unmarried dads get the right to, say, object to an adoption. Because there are some undefined quantum of unmarried dads who are situated just the same as unmarried moms. They're involved with their kids, they have paternal affection, they should have all the same interests that the state wants to put forward. So, what the court says in these cases is the state either has to give their own opportunities for dads to show that they should get the same rights as moms, for example, by filing a paternity petition or signing an acknowledgement of paternity, or else the court will haul the law invalid as applied to those involved dads as a matter of equal protection. So they frame it as an either or. If the state's given those opportunities and the dad didn't take them, they can be held to that and not get their day in court. But if the state didn't give them that opportunity, then the courts give them that opportunity. So to map those cases onto the context here, what they suggest is that the states here should have to give their own opportunities to trans girls, which, to be clear, are the only folks directly affected because these laws are specifically targeted at excluding folks from girls' teams, to say, hey, your reasons don't apply here. I don't have a sex-based competitive advantage, and you should let me compete with the girls. Of course, the state hasn't done that here. And so under these precedents, the Supreme Court should invalidate the laws as applied to those trans girls who really don't have a sex-based competitive advantage. And in fact, what's interesting about these laws is that that actually would essentially just take us back to what the status quo was before these laws existed. The status quo before these laws existed in Idaho was not all trans girls got to compete wherever they wanted all of the time, right? They had sport by sport rules that were decided by the athletic bodies that gave that type of individual consideration. So really the crux of the brief is arguing, yes, as applied, equal protection claims do exist. They exist in the intermediate scrutiny context specifically, and to try to provide the court with some historical context of where we've seen them used most prominently, which is in the non-marital fathers context.
There was such extensive discussion of this issue. Um, and I was sort of surprised at how central a role it played. But when you started to hear the justices saying, well, doesn't intermediate scrutiny start to sound like strict scrutiny? Then I got it. It's like this is part of the sort of trend the court has had of eroding this structure altogether. Um, I have a question for you and to help transition us to our next section. Um, if if the court, given the court's arguments, does it um does it is it does it defeat this problem if the class is defined as transgender athletes or transgender youth or something like that? Like if it's more narrow, does it defeat this problem? Is the problem because sex is considered kind of a broad classification?
Yeah, so they certainly wouldn't need to address this as applied issue if they conclude that these laws, as they should, that these laws target transgender people, right? Because then the question would be, is there a reason for targeting transgender people? So, first, do they get this higher level of review? And if they do, what are those good reasons? And it's really hard to imagine what those good reasons are, right? When you come down to looking at the reality behind these laws of, again, especially cast against the backdrop that they were enacted, which was not open participation, it really does just start to look like animus.
Thank you. I'm going to invite everybody to come on camera now. Um, and we're gonna just have a little bit more of an open discussion about your reactions to, I mean, starting, of course, the as applied theme in the oral arguments, but also just overall your reaction to the arguments. Anything you'd like the audience to take away, or things that you'll be taking away to think about and work on. I'm gonna start with Andrew.
Yeah, and I kind of said this a little bit earlier about kind of uh, the double-edged sword of political powerlessness, that somehow if it's intermediate scrutiny, you can get 95% of the way there and leave out trans people, and that is completely okay, when the court's own understanding of being politically powerless is about how much can you influence, say, political decisions, right? And so that elongated discussion uh, 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 kind of like creates that fracture between like what is intermediate scrutiny versus what is strict scrutiny. But then who gets credibility and validity in the court, right? And so, and as the non-lawyer in the room, I will say that that kind of creates like a empirical challenge for me about how to think about who is powerful and who is powerless. And then also, where do people seek relief from discrimination?
I even think I was it Kenji Yoshino. There was a sort of a scholarly framework that talks about you kind of have to be a big enough group to merit to like enter the arena of a political power conversation at all, and then um, and then um, and then you can start to say, is this group powerful? And Kenji Yoshino has some great writing on political power, as does Nicholas Stephanopoulos. So there's some great research out there to think through that those questions. Let me shift this over to Joshua. Your impressions, unless there was a direct response. Joshua.
No, I think that one of the more practical takeaways that I gathered from oral argument is that this court is, although they're still struggling to articulate um, and really apply vocabulary in this space, they are making efforts to get better. There's a part of this overall uh, conversation nationwide that, on one side, people are prone to catastrophe. Well, really, on both sides, people are prone to, making this a giant catastrophe. What I was surprised with is that the court was able to put forward more thoughtful, more nuanced questions to advocates on both sides, so that they could attempt, I think, to come to a decision that may be more interesting and more nuanced than we originally expected.
Thank you. Michael?
I was really surprised with some of the concessions we saw on both sides. And for petitioners, I was really, really surprised. And I'll take this line out. There are 23 states that are on respondent side that allow trans students to participate in sports. When asked about that, the Solicitor General of Idaho said, and whether or not they want a rule that would prevent states like California from having their policy preference, he said, I have not yet been persuaded by a constitutional theory that would let us use the Equal Protection Clause to impose our policy on other states in this matter. And for those who believe in federalism as an opportunity to move the movement forward, this might be one of those opportunities. But respondents also made a lot of concessions as well. And I counted at least eight, and maybe concessions here is a strong word. And I'm happy if anyone wants to disagree with that. But one, they conceded the baseline legitimacy of sex-separated claims. They conceded they were not offering a definition of boy and girl for the court, at least for this case. They accepted the state's own statutory classification for purposes of the case. They conceded they were trying to give the court an off-ramp for the transgender status doctrine, saying that they prefer a path under sex discrimination. They conceded their approach would not allow every birth sex male into women's sports. They conceded the analysis would come out differently for transgender women who went through male puberty and didn't mitigate that advantage. They conceded the state can impose burdens like testing in some circumstances. And in West Virginia, they conceded the state can keep its own definition of sex. Again, they didn't define it as wrong. And the litigator in me sees two reasons for this. One, It can either be a litigation strategy, knowing how the court is coming out, moderating out of necessity. But maybe it's also something else that we should consider, that these laws and these statutes aren't as extreme as people make them out to be. If we present, or as they presented here, all of these exceptions and ways that would apply to different transgender students, maybe it's just not the end of the world situation that these states are trying to present to the court.
And if we have time today, we can talk a little bit about the evidentiary arguments that happened, which were interesting and complicated, and something that we might normally spend a whole webinar talking about from the Williams Institute. But I want to turn to Professor Iyer. What were your impressions from the oral?
Yeah, so I'll start by saying I'm usually a legal optimist. So I was like the person in Scrimeti who was like, because the doctrine requires this, they will apply heightened scrutiny. And of course, they found a way not to. Um, I will say, my optimism is tempered in this case. I will say that I thought on the equal protection side, they were focusing on many of the right issues, right? In terms of if we were to see a win for the plaintiffs in this case, it would most likely be on this as applied theory on the sex side or on the trans folks as a suspect or quasi suspect class argument. And that was where a lot of the questions were, including the questions from, the justices who are sort of in the middle of the court, thinking about a Amy Coney Barrett or Justice Gorsuch. That being said, I'm not overwhelmingly optimistic that the case will be won. I think most people aren't, just because of a sort of real politic kind of backdrop to this. But I did leave oral argument more optimistic that the justices may be deliberately narrow and cautious in what they say. This case, and we'll get into this more when we turn to what could be the implications, could have been a unmitigated, or it still could be an unmitigated disaster for, say, trans rights under Title IX, and for sex discrimination law more generally under the Equal Protection Clause. And I came away a little bit more reassured that there are justices who are aware of the stakes, who are not just the progressives on the court, and who may try to make sure that their holding is limited and does not reach broadly beyond the immediate circumstances of these cases.
Yeah, I mean, this is not to the. I love your optimism there. Even that I'm not sure about, but the fact that Justice Gorsuch was one of the justices asking about the heightened scrutiny factors and trying to kind of point out the de jure discrimination history, things like that, was surprising and I thought interesting. Although I also have to remind myself not to read too much into it. Um, so given that we've identified sort of all the things that were happening in these conversations, or certainly not all of them, but many of the things that were happening in these conversations, now we will shift to this question of the potential implications, where we see potential impact, and we definitely, I'm not asking anyone to predict the outcome or to tell us all what's going to happen and how to prepare for it, but I do think preparing for the eventualities or the possibilities is important, and understanding where these doctrinal conversations touch on the lives of the diverse range of LGBTQ communities, I think is very important. Um, so and also really everybody affected by these laws. So let's now talk a little bit about the potential impact. So we can go right back to you, Professor Iyer.
Thanks, Alana. So I'll say just a couple of things. I mean, things to look out for when the decision comes out. If indeed it is a loss for the trans side of the case, as many people expect, look for on the Title IX side, are they reaching the question of whether Title IX generally protects LGBT people and trans people in particular, or are they keeping it narrowly focused on those regulations having to do with athletics? If it's the latter, it has much fewer implications for other contexts. And you sort of live to fight another day on all of the other issues that Title IX touches. On the equal protection side, right, this question of are they going to eliminate what has been a way for those who are sort of a minority of a minority to be heard in the equal protection context, which is these as applied claims. That has really important implications for trans folks. It also has really important implications for other groups that may be, the sort of minority of a minority. Non-marital dads, again, is the most obvious, but there can be others as well. And then the last thing that I'm just going to throw in there, those of you who listen to oral argument may have noted that both the advocates and the justices repeatedly were using the language of reasonableness and rationality when talking about intermediate scrutiny. To a layperson, that probably like raises no flags. But to a lawyer, that is the low standard of review. That is not the higher standard of review they're supposed to be applying. So look for whether that language is creeping into how the court is describing intermediate scrutiny. That would be a real blow for any of the groups that depend on that intermediate level of review.
Let's go to Michael.
Couldn't agree more with Professor Iyer, and to underscore that point, there's a part of the West Virginia argument where respondent counsel says, I'd be very happy, however, with this decision to come out on a decision that's focused specifically on the unique context of athletics as opposed to the broad arguments about Bostock applying to Title IX as a general matter. I think that's the definition of a win here. And one reason why, to put a point on it, is these sex definitions under Title IX have direct impact on Affordable Health Care Act definitions. And so there's just a big opportunity there, or a chance that things will be impacted later. But the second thing, this is the former law clerk in me. I heard often petitioners say that adopting respondents' rule and approach would have judicial administrability problems and line drawing problems. And there's this presumption that they're right on that. And then out of nowhere during oral argument, uh, petitioners come out with this two-thirds argument about what might be enough to qualify as a large enough group. They say, well, if you have subsets of one third group of men, another third group of men, and then one third might be at issue, then that might be big enough. I think a takeaway that practitioners have to emphasize in oral argument and elsewhere is in all of these cases, there's going to be line drawing issues. In all of these cases, there's going to be administrability issues. And we can't lose the argument by letting it be presumed that one side has them and the other doesn't. Those are going to be at play, and we have to have stronger, more offensive responses when those situations come up.
Let's turn to Joshua.
I think that so both Professor Iyer and Michael's points regarding how we regarding the importance of how the court is going to cabin this sort of spillover effect is going to be very important. One of the things that I took away from one of the things I found very interesting regarding the questioning was the application not necessarily just outside the scope of athletic sports as it applies, I guess, compared against extracurricular activities. So for those of us who listen to oral argument, one of the questions was, okay, well, what about a chess club? Because in that situation, right, is very clearly within the scope of Title IX, but you have a situation where you have an extracurricular activity that is not sex segregated. And sort of how much spillover is going to be permissible, and how is the court supposed to navigate this very thin line? So the case, whatever the court ends up doing here is going to have applications, not just to Title IX, not just to ACA, not just to, future applications of equal protection as it relates to the LGBT community, but it's also going to have, much more.
We lost your audio.
Sorry. much more discrete and practical applications just within the schoolhouse, right? Within the schoolhouse. And so I thought that the chess club discussion and exchanges were very, very interesting and also, quite frankly, very, very practical. That's sort of a second layer that we saw or excuse me, that we heard across both this case and the companion case was, look, we understand the impact of the constitutional issues here and how this is going to affect, largely the American population. But what about the individuals? What about B.P.J? What about the individual named plaintiffs in these cases? How has this particular issue impacted them?
Yeah, thank you. And I think related to that, there's something that we've touched on a little bit, but that really stood out to me. I've been thinking about just a lot of the ways the court has approached um, its decision making recently, and we've seen a lot of media and discussions on the shadow docket, but also I really appreciate the arguments in this case about the record not being developed, and also the introduction of research and other alleged evidence that is from outside of the actual record. On these cases which are being decided, at a preliminary stage, like a preliminary injunction or a summary judgment motion. So you don't get the benefit of the full factual record. And that to me was actually quite compelling to say, well, we're not ready to decide on these facts. We need to actually talk more specifically about the facts. Um, any thoughts on that before we move on?
I just wanted to add like one small thing. A lot of the focus at oral argument on how the record had not been developed was on the side of the actual evidence about what are the advantages or lack thereof. Um, but another issue that hasn't really been developed is sort of what was the motivation surrounding the enactment of these laws, and that is relevant, right, to this issue of whether these laws target transgender people. But because we're on this early record, that issue also has not been developed. I think it may be too much to hope that the court will send it back for a full trial, but that is another issue that could be more fully developed if they do.
Mhm. Thank you.
I also thought,
Um,
I also
oh,
thought
go
this,
ahead.
I think probably I would characterize as a low point for the other side in oral argument. I don't know if you all recall the discussion about the original meaning in 1964 and whether or not people would consider women to be at a biological disadvantage than men for other reasons.
Yeah.
And even you could hear the justices themselves come back and say, I don't think. And so take that for what it's worth about development on what the original meaning and of an understanding of these terms would be. But for me, that was kind of a what's going on moment in oral argument.
But it was also very telling that the justices coalesced on that point, right? That even though there was a brief exchange with the advocate, right? Like I think that you could sort of hear all of the justices present counsel really, at the time of passage, I think that it was very accepted in popular culture that there was a biological difference in the development of women's brains, how do we reconcile that? Um, yeah, you're
Yeah,
right to pick
can you
up on
even
that.
be a part of the math class? That was Barrett's line
Right.
of questioning too, right? Are women holding men back? And I think that was a targeting question about kind of what are the assumptions you're making and what is the scientific consensus on various things. And though I remain skeptical personally around like maybe how Barrett might decide the case, but having the justices having these questions posed to the advocates, I think, are important in thinking about the nuance. And from a political behavior perspective, the broader public tends to not think so nuanced about like trans people in sports. They tend to think that there are inherent differences between quote biological males and quote biological females, and people have a lot of familiarity with sports, so they jump to a conclusion. And so getting this nuance into the public sphere can be quite important in terms of informing people about how much more complicated this issue might be than what they initially receive it as. And so I'm curious from my perspective where the dialogue might change because we're having these deeper level conversations in the public space.
I think it's also important just picking up on some of the things that Justice Barrett asked. There was a point there in the exchange with counsel where they wanted to sort of go towards the issue of, oh well, locker rooms and bathrooms and this, that, and the other. And you heard Justice Barrett, save it for another day. Let's just remain focused on the issue that we are discussing right now. And so, again, it just sort of goes to what we're all sort of talking about here, that the court is able to appreciate the heightened importance of this line of cases as it relates to a subgroup within the LGBT community, and the additional nuance that is required in order for them to come up with something that is workable across the board.
I do want to, Andrew, turn to you for the end of the section. Is there anything else that you want to think of as a downstream consideration or response to? Um, something to think about, potential implications.
That's a broad question. I will try and answer it from my vantage point. There are consequential components of what this opinion can do in terms of, say, social attitudes and the policy process around trans people access to sports, and then also more broadly around trans rights. My previous research has shown that the Supreme Court has played a huge role in justifying or upholding certain perspectives, and that helps justify to the broader population for those perspectives. So there can be a social impact of an opinion, even if narrowly decided, that has ripple effects and maybe what people, the broader public, might understand about these topics and these issues. And so the court does play an important role there. And so it can grant legitimacy to arguments that maybe many people on this webinar might not necessarily fully agree with, or at least think that these issues are more complicated than maybe how they'll receive them, right? And so in terms of broader impacts, I do have that in mind about having the moniker that this is legal, what some may view as discrimination, right, is going to help shore up or at least solidify some part of the population that this is justified as a type of policy conclusion.
Thank you. I'm going to shift us to some questions from the audience. And I'm going to uh, pitch to the group a question modified from the audience question. So that we are now, of course, waiting for these big cases to get released from the Supreme Court, including regarding the Voting Rights Act. Uh, and of course, LGBT issues have always been inextricably connected to racial justice and economic justice and other issues that affect disability justice, issues that affect LGBTQ community members and that have intersecting legal remedies. So the question for the audience, I'll just sort of really boil it down to this question of how are these cases connected to cases like the case regarding the Voting Rights Act or to the other sort of trends that are happening at the Supreme Court level?
I'd be happy to jump in on that. I mean, I see a few different connections. One is, we've seen a general trend towards the court adopting constitutional rights to discriminate and sort of constitutionally attacking anti-discrimination law. And I see the Voting Rights Act challenge, which is sort of a challenge to the idea of whether race can be taken into account in order to remediate racism as of a piece with that, as is another trans-related case on their docket this term, which looks at whether states can make unlawful conversion therapy for minors. Some people might not see a connection between those cases. I see them as part and parcel of the court's sort of turn towards constitutionally attacking anti-discrimination law and anti-discrimination remedies. The other real connection I see here is on this theme of just ignoring discrimination where it is patent, right? I mean, that has been a long-standing problem for people of color. Most of these Voting Rights Act cases, we shouldn't need to get to the effects test because it's clear what the states are doing, right? They are trying purposely to, diminish the voting power of people of color. But courts have for so long rejected those factual arguments that people are like, well, we need the effects test because courts are just never willing to see it. And that is very akin to the problem we are starting to see in the transgender rights context, where any person on the ground would tell you these laws are absolutely all about transgender people. And yet the court can sometimes somehow have this esoteric debate and say, well, but maybe they don't discriminate against trans people.
Thank you. Any other thoughts or responses? Okay, I'm going to go to the next question. Um, so the Equality Act is a piece of legislation that would amend many federal statutes, including Title IX, to incorporate sexual orientation and gender identity. The question from the audience is, had Congress adopted it, would it have prevented uh, this development in athletics or some of the federal executive orders, perhaps? Thoughts?
I think that's also a question for the professor.
I was going to say, I'm happy to jump in, but I don't want to dominate the questions. So I think the short answer is yes and no. I have to admit, I don't remember exactly what was in the Equality Act about athletics, but certainly it would have taken a lot of the uncertainty off the table about does Title IX extend to trans people, for example? Does the Affordable Care Act protect LGBT people? All of these other statutes. To be clear, there still shouldn't be much debate about that. If you take Bostock seriously, all of these statutes have essentially the same language, so it should extend to those contexts. But the right has been fighting back hard against that, and they've had some success in litigation in the lower courts. So certainly, I do think to the extent there was a perception that the Equality Act wasn't needed after Bostock, that was perhaps a mistake, right? The right is certainly not going to concede these issues. They have not. And there's a lot of stakes to whether, the Bostock ruling gets extended to these other contexts that are critical to LGBTQ well-being.
The only thing I'd
Thank you.
add, if I may, Professor, is that remember the force behind the context of this case is the Javits Amendment. And so, at a minimum, what the Equality Act would do, it would be another data point to show that Congress has something else in mind when it comes to these cases, depending, of course, on what it says about sports. And so, at a minimum, it would remove the force of the Javits Amendment as strong as it was yesterday or a couple days ago.
And all I would add is that I still think that Equality Act would face legal challenges in terms of its definition of sex, and that I think that that the right would still kind of try and find a legal argument that would kind of say that this law is like it's using a sex classification, but not in a correct way.
Yeah, right. And that gets us back to the original question, which is even if you can win on the statutory side, there's this looming constitutional campaign to really undermine civil rights. And that affects LGBTQ people, it affects people of color, it affects people with disabilities, it affects everybody. And it really is concerning.
Before we close, I'll ask one quick question, which is just where you see the next litigation. Not to get ahead of what the answer is going to be or the resolution, but where you see the cases coming up that you think could be, impacted by these decisions. I will start. I think, as we heard, there was plenty of discussion in the oral arguments about the states that offer protections for trans athletes and how they would be affected by a potential decision in these cases. And I think, downstream, there's all these questions about the spending clause that we don't really get into. in this case, and this question's about whether the federal government, for example, could ask a blue state or a state that has a protection to undermine its own laws. And I'm very interested in the federalism issues there, or the question of whether a state like Minnesota or California or New York or Maine could then say, well, this is my state law and I have the right to enforce it, as opposed to a funding condition. So I think that there's going to be some stuff. There's already cases, of course, as a result of the executive orders. Are there any other places you see potential impacts?
I mean, depending on how they write the case, certainly there could be impacts for all of the other contexts that Title IX reaches, restrooms, locker rooms. There are, circuits around the country have split on that issue, and thus far the court has, they granted cert once on it and then dismissed as improvidently granted. Some people may remember the GG case. But they haven't taken it back up. I mean, I think that is an issue that we should expect to see come back up to the Supreme Court at some point, given that there is a defined circuit split on it at this point.
You're muted, Alana. Sorry.
Uh, communicating with my mind. But thank you all so much. We have to wrap now. I want to thank our panelists so much, Michael Horta and Joshua Quay from Boyce Schiller Flexner, and Professor Andrew Flores from American University and the Williams Institute, and Professor Katie Iyer from Rutgers Law. Thank you all so much. And of course, this is just small part of a bigger conversation, and I'm so glad to have had a little piece of it with you all today. Thank you.